Looks like the parties are ready. Ms. Ruhtenberg.
Thank you, Your Honor. Counsel. May it please the court, my name is Maria Ruhtenberg. I represent Amy Rasmussen in this case. In this appeal, we challenge today the sentencing that was imposed on her by the district court. She was originally charged in 2 counts of serious misdemeanor assault causing bodily injury and involving 2 separate victims in an altercation outside of City Hall in Boone. Arising also out of that situation was a separate simple misdemeanor case that was charged with disorderly conduct and I think a harassment. And as part of a plea agreement in the matter, she entered offer pleas to the indictable assault cases in exchange for the simple misdemeanor case to be dismissed. There was a different alleged victim in the simple than there was in the indictable. So at the sentencing, the court heard a victim impact statement from the victim in the simple misdemeanor case over the objection of counsel and stated that it was going to consider that statement as insofar as a no contact order. So in context,
The defendant agreed to the entry of 3 no contact orders, correct? 2 from the serious misdemeanor case, 1 from the simple?
So what happened was part of the plea agreement, if you look at the agreement, well, the Alford written plea form doesn't really mention no contact orders.
I'm looking at page 16 of the transcript. Mr. Doran, we are not contesting a no contact order, so I don't see where her victim impact statement has any relevancy to the issue before the court. So, and they're talking about the third person, I call it the Stecker individual, correct? So isn't that the defense counsel's own words to the court? We are not contesting a no contact order for Stecker?
Yes, that is what counsel said. However, that was not part of the agreement. On page 4 of the transcript, the prosecutor told the court that there was no specific agreement about the no contact orders in general, and specifically requested that the no contact order from the civil misdemeanor be transferred in one way or the other to this case so that the no contact order can continue for Ms. Stecker.
Said the agreement is, and dismiss what the defendant's counsel said the agreement is.
The fact that counsel said that we're not contesting it doesn't mean that the defendant agreed to it. So,
Counsel. This is defense's counsel that said that.
So if it's all wrapped up in a couple different things. First of all, our argument is jurisdiction. But if you put that aside for a second, the question becomes, can counsel waive that authority or right that the defendant has to give up that authority? Because if the court finds that this no contact order was entered in a dismissed case where there's no just jurisdiction or didn't have authority to do so, the defendant may be able to waive that. We disagree with that position, but counsel shouldn't be allowed to do that for her.
Waive. Did you ask defense counsel?
Did I? I haven't talked to defense counsel, but it's not part of the record, and I don't think that I can supplement the record in that way.
Before you make the argument before us that the defendant, didn't agree to it, and defense counsel, I guess.
I'm assuming that's outside the record, what you just said. Is it in the record that defendant did not agree to that, and that was defense counsel misstating the agreement? Otherwise, all we've got is defense counsel saying we do not contest entry of a no contact for Stecker or Steckler.
No specific agreement. Was not part of the plea agreement. Part of the argument that the defense counsel was making with regard to the victim impact statement was that he did not contest the entry of the no contact order with Ms. Steckler. That's unfortunate, but I think if you read the transcript as a whole, the court never addressed Ms. Rasmussen as the court would otherwise do when a...
Ms. Jett, was it? You were asking, that was an agreement. A judge can do whatever he or she wants, but until the judge enters an order saying simple misdemeanor is dismissed, it's still a live case. And at the moment that third victim gave her impact, and I don't remember who read it or if they were just submitted in writing, I guess it doesn't matter, but the moment that that third victim's victim impact statement was presented to the court, that case had not yet been dismissed, had it? So what took away her position as a victim if there's still a live case?
A victim in the case at bar at the time. There was the agreement. She was in a separate case. She was listed as a witness in the indictable case. She was the alleged.
It was certainly before the court. Otherwise, how would the court ever know to dismiss it?
Acknowledged that she was not a proper victim to be tested or to be given a victim impact statement in the district court proceedings.
Correct. That may well be true, but I mean, the record seems to indicate the district court made it clear they weren't relying on that as far as sentencing on the indictable misdemeanors. But as I read the end of the transcript of the hearing, the judge asks, move to dismiss, this is the agreement, yes. The case will be dismissed. As I understand it, the no contact order is to continue, though. Counsel says yes. And then it says, so at this point, the misdemeanor case hasn't been dismissed. This is different from the case we had recently where we had one where the restitution was imposed after the case had been dismissed. It seems to me, the court still has jurisdiction at this point when they're talking about continuing the no contact order, right?
If memory serves, and it's been, 2 days, I think, since I looked at the docket, but the order dismissing the simple misdemeanor and the no contact order were entered virtually at the same time into the iDocket. So that seems to me that once, especially given the language that this court used in the recent case, that once there is a dismissal, the court does not have jurisdiction. And at some point, that reach of the court, of the district court, to punish the defendant has to end. And
why doesn't Petrie cover this case? State versus Petrie?
I'm bad with case names. I'm sorry, could you remind me?
About defendant's agreement to pay costs after dismissal.
Well, the no contact order in this case, I go back to my argument that there wasn't an agreement to extend it, but a no contact order is a lot different from paying court costs. There is a restriction, that was actually argued as part of the sentencing hearing that, the defendant wanted to be able to go to Boone County events like Puffer Billy Days and other events, that she was concerned about that as part of this case. And in a no contact order, which even if the case is dismissed, the no contact order is still valid. So it's a situation unlike court costs where there has to be a level of proof in order to impose a no contact order. There is mandatory jail time. There is arrest involved. So it's not innocuous where, like in a court cost situation where if you don't pay your court costs, it goes to collections or something in that matter.
And the no contact order that you're contesting involves Ms. Stecker, is that correct? And that was filed in a separate case with its own complaint and a separate case number, is that right? Okay, so, and Petrie was dismissed counts and a multi-count trial information filed in one case.
Yes, I think so.
This case, like this case, is that right?
Was where costs were assessed on dismissed counts. And I think there is a distinction because even in a cost situation, I would argue that the same analysis applies as the analysis that this court had in the recent case regarding restitution, that once a case is dismissed, jurisdiction is over. And the witness or the defendant should be released from the responsibility of punishment at that point, whether that be court costs, no contact order, restitution.
Sequence, could the sentencing court have imposed a no contact order regarding Ms. Stecker and filed it with the indictable offenses?
Legal, since she was not a victim in that case.
664A.1, a person who has suffered physical, emotional, or financial harm as a result of a public offense committed in this state. Why would she not qualify? She was there. She was actually, and the only reason, from my understanding of reviewing the file, it cannot be a count 3 of the same trial information because it's a simple. Simples are always outside trial informations, aren't they? They're never included in trial informations. So they couldn't have put it in there as count 3, but she certainly, I believe, same date on all 3 charges, same police reports. It's the same incident, isn't it?
Then the actions against Ms. Stecker are different from, and that's why they charge them different. They charge them.
1 and 2, but it's all from the same ruckus, for lack of a better word, that transpired the same day. We're not talking about different events, are we?
Charges. And I think if you're a victim in a case, the court can order a contact order. If you're not a victim in a case, I don't believe the court can validly order a contact order. There might be other ways to do it in a civil situation. I don't know if it could be part of a probation that's not a...
Could have said, I'm going to entertain a civil protective order, and I'll wait to dismiss the simple until that's in place, and then dump the simple. So, or maybe, are you disagreeing that he could have put that third victim in the SRCR case?
I do not believe he could. No.
Authority on that?
Let me look at the... Can I just... I'm not sure if I brought the no contact order.
While you're looking, so if that third no contact order would be dismissed because it was put in the wrong case, whether it's a jurisdiction or whatever issue, there's going to be a gap before that same person has an opportunity to request it the civil route, correct?
Yes.
Any protection for what could be considered perhaps an oversight or a almost like a clerical error, putting it in the wrong number?
You know, I mean, this is a plea agreement not only with the defendant, it was with the state. If the state wanted this no contact order, it was the state's decision to dismiss these charges with regard to Ms. Stecker. So if the state wanted, I mean, the prosecutor clearly didn't even entertain the thought that he could have a no contact order and dismiss case because he wanted that transferred over to the indictable case, which he stated in the sentencing order. So
about it a lot more than they would have, because from the record, everyone thought it wasn't a fight. There's going to be an NCO and all 3 victims. But you're saying you don't stand by that, even though defense counsel said that at sentencing?
My argument in that is, if you're saying that there is jurisdiction, which we would contest, then the only way, like the Court of Appeals ruled, was that if there was authority for the court to do it and they consented to it. If there is a situation where the defendant is giving the court authority to do something it otherwise doesn't have authority to do, my argument to you is that the defendant should be addressed by the court as a defendant would and otherwise be giving up other rights that he or she has.
This order was entered before dismissal of this charge. Is that okay?
Well, once the charge is dismissed, the problem there is if the no contact order was entered at 2:25 and the dismissal was ordered at 2:26, the no contact order is still there. She's still subject to that. She's still subject to jail time. She's still subject to being arrested. It's still on the call in when the police officers call in if she's found to be in violation of that no contact order. So if the case is dismissed after the no contact order is entered, it should dismiss a no contact order. In
this case, let's assume that we agree that this is an illegal sentence situation because it's not authorized by statute. If that was part of the parties' plea agreement, the state contends that the answer here is not to vacate the sentence, but it's you undo the plea and you let the parties start from the beginning. What is your position on remedy?
Wow, without, I haven't really thought about that, I'm sorry.
If you're right, and the contract was illegal, because you can't bargain for an illegal sentence, then if the bargain is illegal and the object is illegal, then the parties should be put back in their original bargaining position, which means the sentence, or this is vacated, we send it back, and you can start from scratch.
With that. Thank you.
It's kind of a confusing clock. That's okay.
Thank you, Your Honors, Counsel. I guess before jumping into questioning, where I'd like to start is, I think, to frame this up properly, which is the agreement to the entry of the no contact order in the related but ultimately dismissed simple misdemeanor case was an agreement by which everyone stood to benefit. Ms. Rasmussen had to plead guilty to one fewer offense. The victim was protected, which was ultimately the state's interest. Likely the only reason we're here is because she's now seeking to go back to be resentenced because the district court chose not to take either of the more favorable sentencing options that the parties had suggested. And so now kind of a component of the sentence to which she wouldn't have otherwise objected is maybe her foot in the door. I think that's really what we're talking about, and I think it's a compelling analogy to look at the statutory framework under 664A and then the statutory framework for the restitution. I think Petrie, the decision there, can easily be grafted over onto this issue because we're largely dealing with kind of equitable components of the sentencing.
Assessment of what happened is probably right, and maybe this does happen. But can we agree that sentencing is wholly governed by statute?
At the risk of getting myself in trouble, I will agree with you so far, yes.
We agree that the parties cannot bargain for a sentence authorized by statute. They couldn't agree, for example, that she stands on the street corner with a sandwich board for a weekend and have people yell at her.
Again, I think I would agree, and in fact, I think there's been recent cases in which the state has argued that the district court could not impose a permanent no contact order of only a single year rather than the 5 under the statutory framework.
Authorized by statute.
The statute says.
So the simple question, it seems like in this case, is if we agree on the premises, is just point me to the statutory provision that allows for the entry of a no contact order when there's no judgment or deferred judgment.
Sure, and Your Honor, that is why the state has pointed to Petrie, because I think if you look at the statutory language for both restitution orders.
Let's follow the premises. I just want the citation to the statutory provision that gives legal authority for a district court judge to enter a no contact order in the absence of an underlying judgment.
So I apologize for beating around the bush. Obviously, I have none. The statutory language, what it contemplates explicitly is when someone is convicted of, pleads guilty to, or receives a deferred judgment for. Kind of those are the explicitly contemplated. 664A. Correct. And that's after you have the temporary no contact order for the pendency of the case. Then it kind of at the culmination, the court can either get rid of the no contact order and terminate it, or kind of turn it into this permanent 5-year no contact order.
Law?
Consistently upheld, even most recently, I think, by McMurray in 2019, which did quibble with and change some of the restitution-based language about how different things should be apportioned, but it made clear at the end of all that the ability of the parties to bargain for the restitution orders, even if not explicitly contemplated by the statutory language.
In Petrie, it was the assessment of costs for dismissed charges and a multi-count trial information, but there was a judgment entered on at least one of the charges in the case number. And that is not true with respect to SMCR 114872. Is that correct?
Correct that this is different in that regard. I would argue, and I forget, it may have been the chief that mentioned a minute ago, the problem, if it is a problem here, is that you have kind of indictables and non-indictables, which are going to be in separate cases. So normally, when you have these charges arising from the same nucleus of facts, they would all be charged together, and you wouldn't run into this. The state's position would be that it would be kind of an illogical result that in any other case where all of the charges are housed under the same case number, you can do this thing. And then in this type of instance, you can't. I think in many different cases and in various places, this court and others have recognized how much of criminal law is now dealt with by guilty pleas and plea agreements. And I think public policy-wise,
Like, let's say a particular county attorney's office just said, you know what? I really like these no contact orders. I think whenever we do a guilty plea in this county, I want a no contact order with everybody in my office. The defendant has to enter one as part of and the defendant agrees to that. Is that okay?
and I think that's where it becomes a little different. I think there, now you're dealing with people that would be outside of the definition of victim within the statutory framework, similar to earlier where you would potentially be dealing with, for example, and I'm forgetting the name of the case, it's Widerin or something, where the court said in the restitution context, you can't, on an acquitted charge, you can't have, or maybe it was a no contact order, you can't do this because there, the case has been resolved and there's been no finding of guilt, so you can't, even with a victim who wants protection, it's just not allowed. There's no authority to do it. Here, where it's not that, but it's kind of a gap in the framework, I think that's different than also that situation with the 1 year versus 5 years, where the court cannot do something that is contrary to the language.
On the question of remedy, let's assume that we conclude this was an illegal sentence and they couldn't bargain for it. Does that mean the no contact order is stricken as void, that the charges are reinstated, they're free to bargain? And was this part of a global plea agreement and all of the sentences should be undone, and then she's put in the original position with all 3 cases pending? Or maybe it was 2, I'm sorry, I can't remember.
The answer is I think the last thing you said would be correct, that you would need to reset the parties, similar, I think it was Soretti, and give the state the opportunity to reinstate dismissed cases that was part of the plea. I think a couple things there.
Is that because they were global? They weren't negotiated as separate deals?
And I do take counsel's point as correct, that I don't think the written plea agreement talks about the no contact orders, but the way I read the transcript is that when counsel is saying that there wasn't specific agreement, I think there was some disagreement about whether it should be the length of the no contact orders, that they were going to argue different lengths, and so there wasn't a total agreement, but ultimately both sides agreed that no one was contesting the entry of the no contact orders, just as a bare fact.
What's going to effectively happen if it would go down that you can't do this, and there's a lot of wheeling and dealing to try and make things happen in district court, and many times the first ones to go are simples. It's just kind of a pretty common factor. And so if victims and simples are going to no longer have any safety net, if they cannot be wrapped up within the, I'll call it the case in chief, maybe the bigger one, maybe they're going to plead to a C to get rid of a couple Ds and a serious and an ag and 2 simples, and you can't put simples on a trial information. Is the message going to be victims of simple cannot be protected, they have to go to civil court?
That, or I suppose the other option would be that if it goes back, the simple case is reinstated, that there's just no wiggle room and the state cannot protect the victim without demanding that she also plead guilty to that count. That count can't be cut loose because they need something to attach it to if in fact the line is drawn between those cases. I would suggest a couple other options. The state would not concede that you couldn't, because the state originally had asked for that no contact order to be pulled into the serious case. I think there is room that the definition of victim is broad enough that that could be construed that she is also a victim, even because in her victim impact statement, she talks about being personally fearful as a part of these events. I think she could be pulled in because of that, and that would be one kind of middle ground option.
It's, the record shows something about, not only was the simple victim herself, I think, kind of pushed out of the way, not as dramatically as the other two, but doesn't her victim impact statement talk about the impact that the most egregiously hurt person, watching her be kicked in the head, the impact that had on her?
Yeah, and there's a little bleeding now between the victim impact statement and victim for purposes of the no contact orders, and I think they are a little bit different. You know, the Tesh case in the victim impact statement realm talked about how the husband in the car accident was actually a victim because he was harmed by the criminal act, but because of the wife's harm flowed through his, she wasn't. I think the state's position most accurately framed would be, I don't know, although I wouldn't concede that she could be a victim for having witnessed the harm to someone else. I think the firmest ground is that she's a victim because she is personally fearful for having been involved in this overall scuffle, even if it doesn't arise from the physical harm of the simple assault where she was elbowed or shoved.
Affirmed as is, what do you propose for a remedy?
So I suppose my first option, assuming we're talking about not affirmed as is on the no contact order issue, I suppose my first option would be that the court agree that she could be considered a victim within the context of the serious case, and the no contact order could be pulled and entered in that case. Barring that, I think because the state has an interest in protecting all three of these women, I think it's more fair to send the parties back to renegotiate this consistent with whatever the court's opinion is, rather than excising that and leaving one of these women feeling unprotected.
And maybe I'm overlapping with some things you've already covered, but I'm trying to figure out what the massive cost would be of having to go ahead and add that simple in. I mean, you know, if you pled this deal and part of the explicit deal had been to plead guilty to the simple as well as the others, I feel like the state could still reach agreements with defendants that would, and make appropriate concessions one way or another. And I don't see that as a high cost proposition, but maybe you can help me.
Sure, so I guess my answer would be twofold. I think first, again, kind of as a larger public policy, I don't see the benefit or purpose in kind of carving out simples as kind of lesser protected, where because just by nature of the way they're handled by the court system, you know, those are off on an island alone. I think without specific facts here, I guess the best I can say is that the parties, given the nature of the plea deals, should be allowed to engage in this kind of mutually beneficial agreement, and that, you know, once the party consents to the authority of the court to enter this order, they shouldn't be able to renege as a means of kind of sidestepping into avoiding what ended up being an unfavorable sentence otherwise.
What's the limiting principle then? Let's assume you have a judge who wants, you know, we're going to dismiss simples in this county if you give a donation to the Fireman's Fund. We need to raise a new park. You donate $100. You know, who cares? Like, it benefits everybody. So what is the limit? Why couldn't a judge do that if you're right, as long as the parties mutually benefit from some sort of unauthorized statutory agreement, then we don't care?
I get those specific examples, I guess I would have a lot of problems with it. The simplest way, though, is I think, again, because of Petrie, and I think the way this court has framed things, we know that the court has jurisdiction to do this. It's a matter of whether it has the authority in this specific circumstance. And authority can be waived or consented to, unlike something that is just completely out of bounds.
All with the expungement statutes in any way? So if you have cases that were dismissed and there's no judgment, and you have a 5-year no contact order attached to it, that can be renewed unless the defendant disproves harm for another 5. So now you've got a 10-year no contact on a dismissed case that somebody may want to expunge. Is that a problem?
I don't have a case site to give you to answer that. My response would be, and if I'm going to go over, if I can have a second just to think it through. Thank you, Chief. I think in that circumstance, because as you said, 664.8 contemplates essentially an endless series of 5-year extensions on the permanent no contact order. Whether you have a prison sentence that you've long since discharged, or potentially, because the statute explicitly contemplates a deferred judgment that could then potentially, you successfully complete probation and the deferred judgment is expunged, or I'm trying to think through all the possibilities. I think we have to be okay that you're going to have a no contact order that exists after a case is over one way or another. And so I think given that, because of the sequencing here, because the no contact order was entered before the case was dismissed, I don't think we run into the issues from a couple weeks ago. I think the court had not been divested of jurisdiction to enter the order. I think we would be talking about something different. So for those reasons and the other stated.
And talking about kind of where this potentially goes, and if we were able to conclude that Ms. Stecker was a victim, I'm looking at 915.10.3 that defines victim as a person who has suffered physical, emotional, or financial harm as the result of a public offense or delinquent act other than a simple misdemeanor committed in this state.
Just so I understand your question, that is for the victim impact statement code portion. That is not the same definition of victim in the no contact order, which does not include the language about not simple misdemeanors.
Would there have needed to have been some factual finding that Ms. Stecker was a victim of one of the other crimes for us to do what you've asked?
If it was a contested issue, possibly, but again, I think because we're dealing with a plea agreement where the parties are both conceding that it's appropriate, I don't know that the court has to make an additional finding. I don't believe under Petrie, once the parties have agreed, the court then has to go beyond that and make some sort of fact determination. I think once the parties have agreed, that has been deemed acceptable.
On the bench?
So with that, the state would request that you affirm the Court of Appeals and affirm the sentences imposed.
Ms. Ruhtenberg.
Thank you, Your Honor. Just briefly, the no contact order code section is pretty specific about when a no contact order can be issued and for what purposes. And under that statutory scheme, I do not believe it's appropriate to take a victim of a separate case and just plunk her in with another case where she is not the alleged victim. I know we want to talk about practicalities. I practiced that along.
She is, it's just because she didn't get hurt enough that she wasn't an SRCR. She was within that melee of going on at City Hall.
It qualifies for a no contact order under, the statute until her case is dismissed. What we
see where we're headed here, because it feels like to me the only way the state can really protect victims is just to not let you get out of simple misdemeanors. And is that the rule that we should impose? That's what this
impose? I think it's a reality that for the purposes of a no-contact order, like when I did practice, and I practiced in Boone County, and we did a lot of horse trading and negotiating and saying, well, I want a no-contact order for this victim. I'm like, okay, well, let's plead to something that we can get a no-contact order for. You know, that it might not be the domestic, it might be a simple assault or something else like that. That was done on the daily basis in Boone and other counties.
We're talking about here.
Because of the way the no-contact order statute scheme is, and the fact of the jurisdictional situation, and the fact that it's illegal to impose a more restriction and punishment on a dismissed case, it does make it completely different. In a case where
Victim within the large case, correct?
But she's not, because she wasn't charged in that large case.
So you think that if, for example, when no contact orders are entered for a sibling strip because one has been sexually abused by a parent and the other sibs are included, but they aren't the ones that were abused, do you think those are all wrong too?
I think that there's a difference between having, and I don't know if there's a difference between having a no contact order and, let's say, if it's in the same case, and she was a victim in that same case, but her charge was dismissed, and maybe it was a part of probation, the court can say you can't have, contact with anybody involved in this family or what have you. I think that's a completely different question than if a no contact order can be entered in a dismissed matter.
About, let's change gears just a little bit. We've been talking a lot about the no contact order. There was a screenshot at sentencing that was referred, or maybe at sentencing, I guess, plea and sentencing, social media screenshot that showed your client allegedly mocking I call it the third victim, the simple misdemeanor victim, for her injuries. I think it was the third one. No, it was the main one, excuse me, in the SRCR. There was a social media screenshot showing the defendant mocking her for her injuries. Did you, whether you or the defense counsel, was that ever contested as far as the validity?
That was entered. So during the sentencing hearing, this victim referred to Facebook messages about that.
Documents, right?
Request twice. She did hand over her medical records and some.
That's not how I remember reading it. I thought she said, "I have it if you want it," and he said, "Yes, I do."
He said she had referred to it during her victim impact statement, and he said, "If you would you like to submit those as part of your victim impact statement?" And she said yes, and then the other victim gave her impact statement. And then the judge went again and said, would you want to do this? And I can, make it a higher level security. He then said, I will consider those matters. They were entered into the record as, as part of her victim impact statement, therefore not subject to cross-examination. So counsel was not able to challenge the validity of that, and that goes to the other issue that I did raise in my brief about the court considering things like that weren't tested. Other harassment and allegations of crimes my client allegedly committed without proof. And if you look at the way the sentencing hearing went, disregarded the sentencing recommendations of both the state and the parties and went wholly with what the victims requested. And as there's...
Before you run out of time, please. Earlier we talked about remedy, and we talked maybe that the plea would have to be undone on the simple misdemeanor. But I think the state raises a fair point that if you have multiple cases, and this was a global settlement agreement, that the entire deal should be undone and the defendant should be put in the original position prior to the entry of the plea agreement. What is your position on that?
Thank you.
Case of State versus Rasmussen is hereby submitted, and the court is adjourned for the day. Thank you.